I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person. Of identification parade, there is the issue of the clothes which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner. Again, for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nanda treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages or 35 pages, is really a summary of what the parties submitted. Okay? But I would like to read it out in brief for us to move. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following, that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth, changed into those clothes, went to the deceased house, committed the murder, changed out of those clothes, and does it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that the first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Haron entered the deceased house and left. And as saying those contradictions arise from the record held by the protected witness number 3, the guard at the gate, that shows that Haron entered the deceased house at 23:21 and left at 23:31. And therefore that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? They have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Janice, that the first accused person had a bag in which he carried a white counsel when all other witnesses do not speak to a bag. They have invited this court to consider that the accused person has said he didn't know the deceased, and therefore there is no way he would have even known that he was coming from South Sudan. They have told this court to consider that when you look at the ID card of Becerra and you look at the accused person, there is no relationship. They have invited this court to take cognizance. May I request that you probably stop there for now? Thank you very much. I realize that I need the attention of the council, but they need water, so I hope you have water. This court has been invited by the first accused person in his submissions to take note of the fact that there is a message that was sent to PW16 Kaka from the phone of the deceased person saying, "Kuja unisaidie kulala." And that if that message got to the deceased Sudanese boyfriend, he would have gotten infuriated, he would have gotten annoyed, and probably would commit the murder. This court has been invited to consider that the forensic evidence showed that other than whatever evidence the prosecution had brought, there were 2 other unknown male whose DNA was found on the strappings that were used to tie the deceased. And so the argument by the first accused person is that it is these 2 other male persons, they are known, that must have committed the crime. This court, I said the first defendants treated me to quite lengthy submissions, and I took all of them into consideration. This court has been invited to note that the allegations by Brian Kasaine Spira, that he was called by the first accused person at 2 a.m., asked for paraffin to go and burn some items, is not true. This court has been invited by the first accused person to find that the shot that the prosecution produced in this court, having blood stains of the deceased and which has been attributed and said to belong to the first accused person, is not the shot which the police collected from the first accused house. That if the prosecution needed to prove beyond reasonable doubt that shot is the same shot they collected, they should have brought a photograph thereof. This court has been invited by the first accused person to make a finding that the identification process was flawed. This court has been invited by the first accused person to find that there was an intention by the investigators to fix the first accused person, and that is evidenced by capture of a wrong vehicle somewhere in Karioko to tie the evidence of a witness who said that the first accused person told him he stays in Italy. This court has been invited by the first accused person to make a finding that the evidence by Jennings PW8 that he drove the second accused person's vehicle is a lie, and that he had his own vehicle and at no time did he drive the second accused person's vehicle that was with the first accused. The court has been invited to make a finding that there was no blood stain at all on the shot that the deceased had, and which was, the first accused had, and which was collected from his house. The court has been invited to consider that the investigating officer did not investigate satisfactorily or adequately whether the deceased Sudanese boyfriend was in Kenya and could be a suspect. The court has been invited to note that other persons who were in the deceased house on the material night were never subjected to an identification parade. And so, in a nutshell, the court is being invited to make a finding that the prosecution have not discharged their burden of proving the case against the first accused person beyond reasonable doubt, and he should be given the benefit thereof. That this court do dismiss the case against him for lack of merit. So, having considered the evidence that I've spoken to and the submissions, I've raised the following issues for determination. 1, whether the first accused person knew the deceased prior to her death. Secondly, whether the first accused person stole and used the stolen identity card to access the Moria Gardens where the deceased was staying. Thirdly, whether the clothes that the first accused person was wearing on 19th of September 2018 implicates him in the commission of the offense. Fourth, whether the accused person was in the deceased house on 19th of September 2018, and whether he was the last person to be seen with the deceased. The fifth item, question. Whether the first accused person had a gun on the particular night and used it to subdue the deceased. The next issue I'll be looking at is whether the first accused person was positively identified on the identification parade. And lastly, but of course not the least but very important, a recap of whether then the prosecution have given this court adequate evidence to make a finding that the first accused murdered the deceased. So let's take the first issue. And the question is, did the first accused person know the deceased prior to her death? And this question has arisen because the evidence of the first accused person is, I did not know the deceased at all prior to her death. So let's analyze the evidence together. I have considered the prosecution evidence and the evidence of PW10, George Kimani, the brother of the deceased, is that he is known to the accused person because they were together at Kenya Polytechnic. As far back as, I think, 2002, they were in the same class, taking the same course in hotel and beverage management. It is the evidence of that witness, please mark the date, on 31st of August 2018, he was with the first accused person in the house of the deceased. The death hearing was on allegedly unknown time, but it's said to be 19th of September. But I am saying, and I said, please mark the date. This witness, the brother of the deceased, says, prior to the death of my sister, on 31st of August 2018, I, my girlfriend, the first accused, and the deceased were in the deceased's house. Ramuria Gardens, same apartment. And that the sister, the deceased, mentioned to him that she was communicating with the first accused on Instagram. That on the material night, the first accused person and him slept on the sofa set, otherwise known as the couch, whereas the deceased and the brother's girlfriend slept, and I'm not saying this for no reason, everything I say has a reason, slept on the deceased bed. It is also the evidence of George Kimani. On 19th of September, the deceased sent him a screenshot of a conversation between her and the first accused. And that conversation was to this effect. The first accused was telling the deceased that when he returns from Mombasa, he would go and see George Kimani, that is the deceased brother, for a drink. And that the deceased was telling the first accused person, don't spoil my brother. 19th of September. My observation from the evidence is that this evidence of George Kimani, that on 31st of August 2018, he was in the deceased house with the first accused person was not disputed through cross-examination of the witness by the first accused person. And I will tell you why. This was the nature of cross-examination by the first accused person. I quote, "The deceased was communicating with Joey, but she didn't describe how they were. I believe they were friends. There is a night we spent with the first accused in the house of the deceased. We were all happy. I slept on the couch. I woke up in the morning. The first accused person had already gone. When I woke up, I was not very drunk. I wouldn't know what the first accused person did with my sister when I was asleep. I don't know whether he was another man in my sister's life. If he was, I would have known. I did not know Kaka. And my analysis of this cross-examination does not lead to an accused person denying that I have never, I don't know the deceased." Further to this evidence, it is the prosecution case that there was a video retrieved from the first accused's cell phone, which was allegedly recorded by the first accused person, which shows that he was in the deceased house prior to her death. I did not have the benefit of that video. I must make it clear. But more importantly, and this evidence to the court was very important. Why am I saying it was very important? Because the evidence of George Kimani is evidence from a relative of the deceased. I treated the next evidence that I'm going to speak to as independent evidence to the question as to whether the first accused person knew the deceased prior to her death. This is the evidence of number 70110, Corporal Jonathan Limo, who testified as PW33. This is an officer attached to Safaricom Law Enforcement. He's a data analyst, and he said in his evidence that he analyzed data from a telephone number 0727 001675 registered in the name of the first accused person, Joseph Irungu Kuria. He also analyzed data from two cell phone numbers, 0727, 0704 170422, 0715 775856. Both of them were registered in the name of the deceased, Monica Nyawira Kimani. It is the evidence of this witness that on 1st of September 2018, the number of the first accused person called the number of the deceased. And that call was made at DOD Langata, and it was an outgoing call. Based, therefore, on the evidence of George Kimani and the data analyst PW3, it is the finding of this court that the evidence by the first accused person that he did not know the deceased prior to her death is untenable, it is insincere, and it is an afterthought, and it is false. It is the finding of this court that the first accused person was known to the deceased prior to her death. Allow me to move to the next item. next item is whether the first accused person stole an identity card of Dominic Becerra and used it to access Ramuria Gardens, where the murder took place, on the fateful night. I will be probably returning back to this evidence. You will get to know why. But let me speak to it now. Excuse me. Dominic Becerra Harun testified in this court. And his evidence was to the effect that on 17th of September 2018, he went to Royal Park Estate in Langata to look for casual work. The requirement at the main gate was that you leave your identity card at the gate. And so he left his ID card at the gate. And he was supposed to collect it in the evening after work. When he came to collect his ID card, he did not find it. The following day he went, he did not find his ID card. I am speaking to the events of 17th September 2018. And so, he left his contacts written in the book with the guards, the occurrence book, contacts, Dominic, telephone number, and said, turn into a bit of Kiswahili, mukipata hii kipande changu, tafadhali mnijulishe. I have had the benefit of that record. It is his evidence that he never got his ID at all. I have had the evidence of the witness who came from the Registrar of Persons who has confirmed to this court that Dominic Becerra Harun eventually got a duplicate ID in the year 2019. There is evidence from witnesses at Royal Park that is true, Dominic lost his ID. There is evidence from Protected Witness 3A to the effect that the person who went to the deceased house on 19th of September 2018 produced an ID in the name of Dominic Becerra Harun. This witness identifies the first accused person on the parade as the Dominic Becerra Harun. I'll come to the parade. And so, at this stage, I find adequate evidence that the ID of Dominic Becerra Harun was stolen at Royal Park Estate in Langata on 17th of September, 2 days before 19th of September, when the offense was committed. I have made an observation that this ID was stolen from Royal Park Estate Langata, and it happens that the two accused persons were residing at Royal Estate Langata. As to whether the first accused person used this ID to access the Ramuria Gardens and commit a murder, hold it. The next question and issue I'm going to address is whether the cloth which the first accused person was wearing on the material date implicates him in the offense. I have taken a route of flow from where he started. And of course, we all start by dressing in our houses. Hopefully. I'm not saying anything. So the first evidence as to the cloth which the first accused person wore was the evidence of Pamela the house help, PW 15. She says that when the first accused person left the house on the 19th of September 2018, he was wearing a white shirt with patterns, a maroon cap or cap, and brown shorts. Now, the prosecution produced a brown shirt marked as exhibit number 9 and a maroon cap marked as prosecution exhibit number 4. And they were shown to the witness, and she says, yes, they look like what he was wearing. And then she's cross-examined by the first accused defense counsel, and I picked an extract from her answer in cross-examination, and this is what she said. Joey left at 4 p.m. in brown shirt, maroon cap, and a small bag. This is not in my statement. This shot is the one produced in court. End of quote. So that's Pamela. What the first accused person was wearing when he left the house. When the first accused person left the house, the next person he met was a gentleman known as Jennings, who was given evidence as prosecution witness number 8. Let's see what Jennings said about the cloth. Jennings confirms that he met the first accused person at Rose's house, and in relation to the cloth he was wearing, he says this. The first accused person was wearing a t-shirt, a maroon cap, and a brown short. Again, he's shown exhibit number 9. He says, yes, this shirt looks like what he was wearing. And he's shown exhibit number 4, and he says, this cap looks like what he was wearing. Jennings goes beyond these 3 items, the t-shirt, the short, and the cap, and says this, that he left Roadhouse where he was meeting with the first accused person, and that the first accused person requested him to drive his car, and of course then he went to the passenger seat. He took a bag which he had. He removed a white kanzu from the bag and a 4th item or cloth, white kanzu, and put on top of his cloth. And then he left to go where he was going. So the second person who speaks to the cloth which the first accused person was wearing is Jennings. And he speaks to a t-shirt, he speaks to a maroon cap, he speaks to a brown shirt, and he speaks to a kanzu. The third person who spoke to the cloth which the first accused person was wearing is PW11, Chelagat. Chelagat tells the court that she knew the first accused person because she is a friend to the second accused person. And Chelagat says that on that particular date, the 19th of September, she went to Roadhouse. Remember, Roadhouse is where the first accused person and Jennings were meeting. She went to Roadhouse in the company of her friend called Juju. They found the place was packed, and because she knew the first accused person, she and Juju joined the first accused person and his friend Jennings on their table. They had drinks and food, and when she's asked the clothes the first accused person was wearing, she says the first accused person was wearing white shoes, t-shirt with some prints at the front, a brown khaki shirt, and a maroon cap. Again, she's shown the white shirt, shorts, the brown shirt. Exhibit number 9, she says it looks like it. She's shown the cap, she says yes, it looks like it. She is cross-examined, an extract from her evidence I took. She says, I described the shirt as brownish. There are back pockets. The shirt had side pockets. At 40-40, he was wearing the same shoes. The fourth witness who speaks to the clothes the accused was wearing is the guard at Lemuria Gardens. And I'm hoping the manner in which I'm flowing my decision is helping us to move with the movements of the first accused. From the house, road, house, and then allegedly we'll come to see whether it's an allegation or it's been proved. Lemuria Gardens. Now, this witness says this, that the person who came to the deceased house identified himself as Dominic Becerra, Harun, came in a taxi and he was wearing a white kanzu. The next witness who speaks to the cloth which the first accused person was wearing is PW7, Lee Owen. Lee Owen says that when he went to the deceased house, he found the first accused person was introduced to him as Joe, and he was wearing a pure Muslim white kanzu. Ash gray coat, red stroke maroon cap. And he says this, that in fact, the deceased person made a comment on the white kanzu which the first accused was wearing. And she said, I've translated it into English but in Kiswahili. Kwa nini huyu leo amevaa kanzu? Kwa kawaida huwa havai kanzu. That the deceased remarked, why is the first accused person wearing a kanzu today? He usually does not wear a kanzu. Now, what comes out of the evidence of these witnesses? About 5 of them. 1, that all of them, Pamela who was at the house, Jennings who was at Roadhouse, Chalagat who was at Roadhouse, 3 of them speak to the same 3 items or cloth that the first accused was wearing. T-shirt, brown short, maroon cape. All of them. Then we have the second set of witnesses, but there is a bridge, which I'll bring. Jennings, the guard at Lemuria, and Owen speak to a white kanzu. The question is this. Why is there divergence? How come Pamela does not speak of a white kanzu? How come Chalaga does not speak of a white kanzu? And the answer was not far from the analysis of the evidence. The answer is, when the first accused person is said to have left the house, he was not dressed in a kanzu. So this kanzu is, according to the evidence of Jennings, was worn just before he went to the house of the deceased. And so anybody who met him before he went to the house of the deceased would not have seen the kanzu. Do these clothes implicate him in the commission of the offense? Hold your horse. Three other things on this cloth. 1, were these clothes recovered? If so, where? The evidence reveals that the short and the maroon cape were recovered and they were produced in this court. The police have brought an inventory that the first accused person is supposed to have signed, acknowledging the clothes were found in the house where he was staying. Those clothes have been shown to the witnesses. They have identified them. But what was not brought to this court was the white kanzu. And how do the prosecution deal with the absence of the white kanzu? They bring evidence to the facts, to the effect that during their investigations they discovered that there were items which the first accused person burnt. And among those items, they recovered the remnants. There was a white piece of material which they believe was the counsel that was not completely burnt. The court had the benefit of seeing the white counsel piece of material. My observation as a court, it was evident that piece of material was stitched. You can see the running of the machine. So it's not like somebody just cut a piece of material and there it was, there were stitches. Which in the logical conclusion is that it must have been a piece of cloth stitched for wearing. 2, and I'm now getting into the submissions that were brought and by the parties. The first accused persons heavily submits on the fact that the shot which has been produced in this court as prosecution exhibit 9 was not the shot collected from his house. And you will understand why that evidence is heavily fought. Because that shot is supposed to be having blood stains of the deceased. Critical. But the evidence is this, that that shot, when it was recovered, it was entered in an inventory, and the accused signed the inventory. The argument of the first accused person is that this shot in this court is faded yellowish. I had the benefit of seeing that shot. There is nothing faded yellowish. It is a khaki brown shot. This court was told khaki is not a color. It is a mixture of nylon and others. The color is not khaki. The color is brown. I had the benefit of looking at that white piece. It's a relatively big piece. And one cannot rule out that it may and was the counsel. But I did also take cognizance of one important thing which none of the parties here submitted to. But I am expected as a judge, as a court, to comb through all the evidence. And I did. There was a lot of contestation on the shot. But it was very clear, no one disputed that the first accused person is supposed and was wearing a maroon cap. So a lot of questions was on white counsel, and the brown shot. No question on the maroon cap. Yet, this maroon cap knits and joins right from the house where the first accused left. The house help says he wore a maroon cap. Jenny's at Roadhouse, he wore a maroon cap. You go to Chelagat, he had a maroon cap. You go to the guard at Ramuria, Haron had a maroon cap. You go to the witnesses who are in that house, he had a maroon cap. A maroon cap has been produced in this court. Does the accused person say it's not mine? No evidence to that effect. I have also considered the submissions by the first accused counsel that the clothes that have been brought to this court are generally ordinary clothes that you can't get in the market. And that they did not have any specific identifiable marks that would pin the first accused. And my simple argument is this. Really, when clothes are manufactured in the factory, they manufacture them in bulk. The only way I will distinguish you are, the other day I saw a newscaster wearing I will not tell you who, a blouse like mine. And I'm sure any one of us can speak to the fact that we wear clothes that are manufactured in the same place, isn't it? The only difference is the size. So if you want to say that my clothes have an identifiable mark, then I should put that mark for that purpose. Otherwise, clothes are just clothes. So the fact that this cloth did not have any marks that would say this cloth only belonged to so and so, for me was not a tenable argument. But my findings on that is that there is corroborative evidence as to the cloth which the first accused person was wearing on the material date. Please allow me to move to the next issue. In that reading, I've done away with quite a bit of material, so you will not wait for too long. Summarized quite a bit of it. And so the next question is whether the accused was in the first accused was in the deceased house on the material date, and whether he was the last person to be seen with the deceased. Now, considering the evidence of PW7, Lee Owen, his evidence is that the first accused person was in the deceased house. Waridi did not testify, and nothing much can follow on his evidence if he has not been tested on it. But the strongest argument the accused person is advancing is that, look, there were these two other male persons. First of all, there were other people, the Kinawaridis, the Lee Owens, the Kakas. Why were they not also investigated? But he advances another argument. The strappings that were used to tie the deceased, the evidence of the government analyst is that it revealed DNA of two unknown males. These are the people who were in that house, and that Dominic Harron. Allow me to make my observation. But before I do that, back to Lee Owen. You know, Lee Owen is the witness who says, I was with the first accused person. And I needed to find out, why is the first accused person in the deceased house for over 1 hour? That was his evidence. Secondly, the first accused person was using coded language. Thirdly, he had a beard. And fourthly, he had brownish eyes. Then he says, in their conversation with the first accused person on that day, these are the words the first accused person said, and I'll quote, that in their conversation with the first accused person in the deceased house on that day, these are the words that the first accused person said. And I've quoted them verbatim. In reference to another country where they account for everybody, not like in Kenya where you can come and do something and just disappear, and someone can impersonate, since we don't have a database. In reference to another country where they account for everybody, in Kenya you can come, do something, just disappear, or impersonate somebody, since we do not have a database. And then, of course, Owen says he identified him on the parade. I'll come to the parade. Other than the evidence of Owen, I sought to find out whether there is any other evidence that would place the accused person maybe in the deceased house. And I came across the evidence of PW25, Chief Inspector Frederick Ngahu. Attached to the Directorate of Integrated Command and Control Center, and he brought records of the movement of vehicle KCA E03E, the second accused vehicle which the first accused person was using, had indicated, without me having to read in details, that this vehicle was within the subject time and the set time within the Dennis Pritt area, and that is within the vicinity of the commission of the offense. And so, it is the finding of this court that there is evidence the first accused person was within the vicinity of Dennis Pritt area, the vicinity of the commission of the offense, and that corroborates the evidence of Lee Owen of his presence in the house of the deceased. But I have looked at his submissions about the two male and the unknown. And I took time to think about this. And this is my findings and my observation. That we are talking about DNA on straps. And I'll repeat that. We are talking about DNA being found of male on the straps. We are not talking about DNA on the body of the deceased. Hear me out. Straps, I've taken judicial notice of the fact that there are items that can be purchased from a departmental store. And they can be handled by more than one person. The seller, the buyer, and the end user. And therefore, the possibility of DNA of more than one person being found on these straps is not far-fetched. It's not unimaginable. If we are saying that this DNA was on the body of the deceased, it would put beyond reasonable doubt that those people were in that house and had contact with the deceased. In any case, may I take all of us back to the particulars of the charge? They say, jointly charged with others not before the court. I say no more. But finally, before I move out of that area, the question that we must ask ourselves is, does the fact that there may have been other people who are still at large exonerate the first accused person from blame? My answer was in the negative. Was the first accused person the last person to be seen with the deceased? The doctrine of last seen was discussed in the case of Kimani versus Republic, where the Court of Appeal said this, and I will read it because it's important. The doctrine of last seen alive is based on circumstantial evidence where the law prescribes that the person last seen with the deceased before their death was responsible for his or her death, and the accused is expected to provide an explanation as to what happened. In the Nigerian case of Achi versus Tet, 1930-1993, the court relied on the case of Eastman versus Tet to discuss the doctrine of last seen. And this is what the court said, and I quote, "In the case of culpable homicide, as is in the present one, where the doctrine of last seen has been applied, the law presumes that the person last seen with the deceased before the death was responsible for his death. And the accused is expected to provide an explanation of what happened. The last sin doctrine stands as negation. I will repeat again. The doctrine of last sin stands as a negation and an exception to the doctrine of presumption of innocence. It is therefore tried law that where a victim was last seen by the accused and is found dead, the death of the victim will be presumed, and it will be presumed that the last person he was last seen with is responsible for his death. Therefore, if the first accused person is the one who was last seen with the deceased herein, as testified by Lee Owen, then the first accused person will have the burden to explain what happened to the deceased. Please have a look at the case of Achbong versus State, 2006, LCN. You'll find it in my judgment. It is the finding of this court that the first accused person was in the deceased house on the material date. And he was the last person to be seen with the deceased. The evidence of the protected witness is that Harun, whom he identified on the parade as the first accused person, left that house at 23, that's about 11, and no one else went to that house. It is the evidence of this witness the deceased Sudanese boyfriend was not in Kenya. And there is evidence that this deceased person was supposed to be traveling the following day to go to Dubai to meet the Sudanese boyfriend on business and holiday. The next issue I'm considering at this point is whether the first accused person had a gun on the material date and whether he used it to subdue the deceased. May I have a little more water? The evidence of Brian Kasaine's Spira, corroborated by the evidence of no other person than the first accused person himself, is that by 19th of September 2018, the first accused person was in possession of a gun. That gun belongs to Brian Kasaine Spira. And so, it is undisputed that on 19th of September, the first accused person was in possession of a gun belonging to Kasaine, PW17. In fact, Kasaine testified that the first accused person had earlier on borrowed this gun to go on what he said a refresher training, returned it, and then he borrowed it again. And according to Kasaine, and this is important, he was supposed to return that gun after 2 days, but he did it. And so, by 19th September, he had a gun. That corroborates the evidence of Jennings that when they left Roadhouse, the first accused person opened the dashboard of the car and removed the gun after putting a white council on top of his cloth and picked a taxi and went where he was going. And so the question is this: if he was armed with a gun and the gun was not used to kill the deceased, what was it for? I am in concurrence with the submissions by the prosecution that the gun was intended and used for the purposes of subduing the deceased. I'll quickly move to the identification parade. The identification parade was conducted by Chief Inspector Arama. Again, I'm fast tracking, so I'll not go through the rules of a parade. There were witnesses when I looked at the identification parade, and critically so, I noticed the following. One, the identification parade listed 4 witnesses who I do not understand how, but anyway, is there, included the IO, investigating officer. But the investigating officer then was not given an opportunity to go to the parade, but he's indicated as a witness. As I told you, I looked at age and everything that I needed to look at. And the identification parade parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade and for the benefit of the office of the DPP, join me in the words of the court in David Mwitawanja and Others versus Republic. Quite good read on identification parade. And this is what the court said. The purpose for and the manner in which identification parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud, and therefore this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade passé. The last question is whether this first accused person committed the offense. And I'll pick on issues I raised and that I've not dealt with, so I'll not repeat what I've already dealt with. The first argument of the first accused person is that he can't have committed an offense in 10 minutes, and that is what I want to address now. And that brings in the issue of contradictions on the time Haron entered and exited from the house of the deceased. It is not in dispute that the entry in the occurrence book at Ramuria Gardens indicates that Haron entered the premises at 23:21 and left at 23:31. 10 minutes. That is not in dispute. And the prosecution explanation to the same is that the entry in relation to what time Haron entered the house is erroneous. That is an error. So I took a journey. That will tell you the journey I took. My journey started with Jennings. Jennings states that they left Roadhouse with the first accused person at 8 p.m. All right? He goes on to state that he then went to a petrol station after the changing of clothes. I've spoken to that, where the first accused person left him waiting with instructions that if the second accused person needed the vehicle, please give it to her, and took a taxi. According to Jennings, by the time they were parting with the first accused person, it was 8:30 p.m. Then we come to the evidence of Lee Owen, who then says when he arrived in the deceased house at 9, the first accused person was there. Now look at this evidence. Lee Owen says, in fact he says, I entered when the 9 o'clock news were on. And the entrance is saying he entered 23. So let's just continue this journey. They leave Roadhouse at 8. They part at 8:30, and by 9, according to Owen, he's in the deceased house. Then, according to Owen, he leaves the first accused in the deceased house. But even departure from the first accused house does not seem to an issue. So the question I've posed for all of us to ask and answer is, if this first accused person left Jennings at 8:30, and by 9 he was in the deceased house, is it possible then the entry that shows he entered at 11 o'clock was an error? The evidence of the timings corroborates a finding that that 23:21 was an error because it does not tie with the movements and the evidence of the witnesses. And so for me, my finding was the argument that I couldn't kill in 10 minutes is not tenable. And I pose the question, if indeed the first accused person, before I even pose that question, I have made an observation that this court visited the scene. This court had the benefit of seeing and monitoring and appreciating the distance from Roadhouse to where the deceased was staying. Less than 15 minutes walk. And so if really indeed this first accused person left Jennings at 8:30, he would not have taken more than 15 minutes to be in the deceased house. And that corroborates the evidence of Jennings. By 9 o'clock, he was in the deceased house. And so my conclusion is the argument about 10 minutes, not tenable. The forensic evidence. Evidence has been produced in this court that the shot which was collected from the house of the first and the second accused had blood stains. Subjected to forensic exercise, it is the evidence of the prosecution that the blood on that shot was the deceased's blood. Lots of issues arose on that shot. Is it the shot that was collected from the accused's house? The accused says no. I ask myself as a court, so are we then saying the police went and bought a shot? Are we saying the police substituted? If they did, where did they find the blood of the deceased to put? Then the accused person advances a further argument. Surely, if there was blood, it should have been seen. I go back to the evidence of the analyst, and he says, and I quote, I think, if I can get it. Yes, here we go. My paragraph 212, my judgment. In cross-examination by the first accused, the analyst stated that the blood stain on the shot was a small spot on the front. A small spot. So one asks, if I were to pick something, was it then generally visible that the scene visiting officer who took a photograph of it, the people who are collecting it would have said, oh, this one has blood. He said it was a small spot. Then there was a question on the storage and the chain of handling. And this is what the witness said, that all XBs are kept in high security cabinet, and this was kept in the high security cabinet marked JKZN. Okay? And in my finding, and it is the finding of this court, no reason has been advanced why the investigating officers would have done away with the shot which they collected from the accused house, find a different shot, subjected to forensic examination, and is found to have the deceased blood. It is my finding that this shot, which was taken to the garment analyst for forensic examination, is the same shot which Pamela, the house help, has identified, is the same shot which Jennings, who was at Roadhouse with the accused person, has identified, is the same shot Chelagat, who was with the accused on that day, has identified, is the same shot which is entered in the inventory. At this point, I want to go to the evidence adduced against the second accused person. I don't need to replay what the state and the prosecution said. I've already spoken to it. But I want to bring in the evidence of the second accused person and the submissions. It is her evidence, and the submission is that I did not know the deceased. It is her evidence and the submission that I had no reason to kill her. In fact, she says in her submissions, if I knew, leave alone killing, that there was a plan to kill her, the conscience of my banks would not allow me to keep quiet. I would report. She says in her submissions, yes, my phone went off, but says, my phone going off is not commission of a crime. And it was not switched off because I was committing a murder. She says in her evidence and submissions, I gave the first accused persons the vehicle. Yes, it was my vehicle, but I have no control over it when he has it. She says in her evidence, no forensic, no data, no eyewitness places me at the deceased house on the material date. She says in her evidence, the people who visited the deceased were of male gender. I'm of a female gender. And no one has said there was a lady who visited the deceased on the material date. She says I've explained where I was throughout, from the time I reported to work, to the time I joined the interview of the former governor, to the time we went to Q launch, and then went to Fort 40, to the time I went home. It was the duty of the prosecution to displace my alibi. They have not. And she says, if they're asking this court to convict me for aiding and abetting or an accessory after the fact, there's no evidence I did. And if there is any evidence of anything I did, it has nothing to do with the murder. It could have something to do with the shooting incident. And tells and analyzes and crushes and says, the murder was on 19th, the shooting incident was on 20th. The murder was by a sharp object, the shooting was by a gun, excuse me. And so they are not related. I am not accessory after the fact. I will not read for you is an accessory after the fact. I will not read for you what the sections on aiding and abetting. You will read it for your own benefit when we come to copy of my judgment. As I read, I say a few errors, we will have them corrected. And so for her, the sum total of evidence adduced, either through oral or documented evidence, does not show that she was involved in the murder in any way. But she says again, I did not witness the burning of any cloth, and then goes on to say, if anything is the case anyway, the clothes were burnt in a public place, and the investigating officer did not establish whose place it was. Then finally says this, my relationship with the first accused person, and she says, then, my relationship with the first accused person then was that of cohabitation and aiding him to get treatment after he was shot. It's a constitutional right under Article 43. If anything is the case, you can't take a gunshot wound lightly. She says, by any stretch of imagination. She then crowns her submissions by coming to the doctrine of last seen and says, if there is anyone to be asked as to what happened to the deceased person, it's the people who are last seen with her, who are Waridi, Kaka, Owen, and the first accused. Let's look at the evidence. The defense by the second accused person is an alibi defense. The law is settled. One, it must be raised at the earliest, and two, it is the business of the prosecution to displace it. So when the accused person says, I woke up in the morning, I did 1, 2, 3, and removes themselves completely from the commission of the offense, it is the prosecution to say, no, you did, what you are saying is not true, you are. And let me tell you why that is the law. Please join me with the case of Kiari versus Republic 1984. This is what the court said. An alibi raises a specific defense. And an accused person who puts an alibi as an answer to a charge does not in law thereby assume any burden of proving that answer, and is sufficient if an alibi introduces into the mind of a court doubt that is not unreasonable. All right? But it suffices to note that relying on an alibi defense, the entirety of the prosecution evidence must be considered, either direct or circumstantial, so that the court is appraised to establish whether that accused person was elsewhere and not at the scene of crime. Further, the conduct of the accused and the decision to raise an alibi during the defense hearing case, if that be the case, should not escape scrutiny of the court. Adedeji versus State, failure by the police to investigate and check liability of alibi would raise reasonable doubt in the mind of a tribunal and lead to the quashing of a conviction imposed. Ricky versus State, Free State High Court, the acceptance of the evidence on behalf of the state cannot by itself be sufficient for rejecting alibi evidence. Something more is required. You can read more on that. My last few pages will be dealing with the conclusion, but I want to take a tour. Because at this point I posed a question, was the second accused person involved in the commission of this offense? I said, hold on. I have then moved to discuss an issue that has played in this matter and has been identified as distinct from the matter before the court, and that is the gun shooting incident. So let's move to the gun shooting incident. By an OB, number 79 of 21st of September 2018, produced in this court as prosecution exhibit number 33, the first accused person reported at Langata Police Station that while he was going home, Royal Park Estate, he was shot by thugs in what was described as a robbery. Subsequent thereto, he wrote a statement to that effect with the police. Similarly, the second accused person on 28th of September 2018 wrote a statement in support of that report that the first accused person was shot by thugs while going home. 28th September, I've had the benefit of that statement. It's marked as prosecution exhibit number 109. I have read it in its entirety. It suffices to note this. On 29th, the following day, the second accused person writes yet another statement on the shooting incident and retracts what she has said in the statement of 28th of September 2019. This time her evidence and her statement is that no, he wasn't shot at the gate. It's an incident that took place in our house. Now, Brian Kasaine Spira, the owner of the gun, testifies that while asleep, the first accused person went to his house groaning in pain and said, "Oh, Brian, please rush to my house and secure the gun." Remember, the gun belongs to Brian. He's given it to the first accused person. The gun has fired or been fired or whatever. So Brian rushes to the first and second accused house and secures the gun. What does he say about his observation? He says, "I found blood on the floor. And that when the first accused person came to my house, he had blood all over the chest." Who else speaks to these events? The house help. She says that she had noise, and when she went to check, she found blood, she found a gun, and her concern was, first of all, to secure the child from that scene. But she says she saw blood. There is evidence of PW27, Eunice Mohammed, who was the caretaker at Royal Park Estate. He says, no, if there was a gunshot incident at the main gate, I would have known as a caretaker. There wasn't. Kasaine comes back. Remember, Kasaine was a neighbor to the accused persons, and he says, if there was a gun incident in our estate, ingewekwa kwa mtandao ya estate association WhatsApp group, it wasn't there. What does that say? It is the finding of this court that the report made to the police by the first accused person, the statement made by the second accused person on 28th of September was false. The first accused person expressly admitted he lied in his evidence in this court, before this court. Now, what is informing this lie? It is very clear that Brian Kasaine had given the first accused his gun without authority. And so according to Brian, when he realized that his gun has been used, his first concern to the first accused person was, what are you going to do? And the words of Brian in his evidence is that the first accused person told him, do not worry. I will take care of that. I will report it as a robbery. Now, let's look at the legal, natural, probable, and moral consequences of a lie. The case of Kinuthia versus Republic, 2003. The Court of Appeal had this to say. I will repeat. Kinuthia versus Republic, 2003, EKLR. The court had this to say. I quote. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. I will repeat. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. The court went on to say, in a criminal case, a witness should not create an impression in the mind of the court that he is not a straightforward witness. That if a witness raises suspicion about his trustworthiness or does something which indicates that he is doubtful, he has doubtful integrity, he will be deemed to be unreliable, which makes it unsafe to accept his evidence. Please also look at these other cases. Kimani versus Republic, MTG versus Republic. My analysis of the evidence. In relation to this issue of giving false or denial, the first accused person says, "I'd never met the deceased." Court data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, "I stay in Emali." Evidence reveals the contrary. The first accused person gives the reason why he's wearing a kanzu and says, "I'm going to meet people in Isli, from Muslim community." He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back. And in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. The first accused person asked Kasain to give him a gun for training. The gun is found, evidently, at the time the offense is being committed, at the scene of the offense. And of course, his own confession, "I lied about the gun shooting." The second accused person contradicts her own statement by the statement of 30th and says, 29th, "Now I'm clear in my mind. The statement I gave you yesterday was a lie." Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last tale of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, "Look at all these contradictions in the case of the prosecution and find that the prosecution have not proved their case beyond reasonable doubt." The case of John Nyaganjuki and 4 others versus Republic. The court says this: in certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. I'll read again. In certain criminal cases, particularly those that involve many witnesses, discrepancies are in many instances inevitable. Philip Zioka Watu versus Republic. Court of Appeal had this to say on contradictions. However, call exactly the same thing to the minutest detail. Some discrepancies must be expected because human recollection is not infallible, and no two people perceive the same phenomena exactly the same way. Joseph Maina Mwangi versus Republic. Lays the legal principle that the court will not disregard the evidence of a witness on the ground of contradictions unless the contradictions go to the root of the case and create doubt as to the guilty of an accused person. And the court had this to say on that. In any trial, there are bound to be discrepancies. An appellant court, in considering these discrepancies, must be guided by the wording of Section 382 of the Criminal Procedure Code. Where such discrepancies are such as to cause prejudice to the appellant, or if they are inconsequential to the conviction and sentence. What are these contradictions this court has been invited to look at? Contradiction on the time Aaron went to the house of the deceased. Contradiction on the cloth. Some people said he had a cancel, others didn't say he had a cancel. Contradiction, one witness said, I saw him with a bag, another one, I didn't see him with a bag. In my finding, and it is the finding of this court, the contradictions the defense has invited this court to look at are inconsequential. They do not go to the root of the matter, and the evidence of the witnesses cannot be disregarded on that ground. I am expected to be bringing the curtain down, but I'll go to the last ingredients, those of us who are working with me. And I have to pose a question and answer at this point. Then I'll come and answer that question. And I will repeat the question. Did the first and second accused person kill the deceased? I will answer it. But if, before I answer that question, let's look at the last element of malice aforethought. I'll look at two things, then I will close. I'm sure you're wondering what is the next thing she's going to look at, so let me whet your appetite. I'll look at malice aforethought, I'll look at circumstantial evidence, then I'll close. I'm sure the lawyers understand why this judgment had to be this long. There was no option out of it. Please join me in looking at section 206 of the Penal Code. And just to save a bit of time, I will not read, because I've captured it from the law. Please allow me not to read, I pass. But it talks about malice aforethought shall be deemed to be established by evidence proving any of the following, then it gives the circumstances. Please allow me not to read. But maybe I need to just point out subsection C, an intent to commit a felony. So you'll be deemed to have had malice aforethought if your intention was to commit a felony. Now, in the instant case, what the prosecution are arguing is that even before the day of the murder, the first accused person had already started preparing, premeditation. And so, how do they support their submission to that effect? We go back where we were earlier. Look at his conduct before. Look at his conduct during. And look at his conduct after. So let's just do a recap. The first thing is that the first accused person, and I've made a finding on that and we don't have to belabor it, the first accused person stole the ID of Dominic Becerra Harun on 17th of September, 2 days before the murder. And why this court has arrived at the conclusion that he stole the ID is because of two things. One, he resides within the Royal Park Estate where the ID was stolen. Is it a coincidence? Number two, the ID was never recovered. The owner had to get a duplicate. And number three, the witnesses to whom he presented that stolen ID have identified him on the ID parade as the person who presented the ID. So it's not hard to join the thread. And my finding is that the first accused person stole the ID of Dominic Becerra Harun 2 days before the commission of the offense. Secondly, the evidence analyzed reveals that this first accused person, other than the cloth he was wearing, he carried a bag, and the house help has testified that he had a bag. That evidence of the house help has been corroborated by the evidence of Jennings, whom he joined and who was his friend. And Jennings says, yes, he had a bag, and it's in that bag that he removed a counsel. So the question is, why didn't he wear a counsel right from the time he left home? Does the carrying of the counsel to be worn just before the murder and removed immediately the murder part of the plan? Does it constitute malice aforethought? Number 3, it is evident that he had borrowed a gun from Kasaini. He was supposed to return the gun after 2 days. He didn't. Then just before he went to the deceased house, he took the gun and went with it. Does the fact that he borrowed this gun even before the due date, or the material date, or the fateful night, part of his plan to commit the murder? The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it. But in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number 5. The evidence of Jennings is that he was left waiting for the first accused person at a petrol station. Earlier on, when they're having drinks and food, they were discussing about setting up a security firm or company. He says that when the accused person, before the accused person left him waiting, he told him, I'm going to meet, he spoke about a girlfriend who was coming from South Sudan. And he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. And I picked this from the post-mortem report, that the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now, this brings me to what played before this court heavily as I had this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting it to the witnesses, have you ever slaughtered a goat? And the witnesses would say, yes. And what impression was created in the court's mind? That the manner in which the deceased was killed was akin to slaughtering a goat. And so the argument of the first defendants, accused, was that if I really killed her the way she was killed, the way a goat is killed, how come the blood didn't go on my cloth? I have had the benefit of looking at the photographs by the scene of crime. And it's very clear that the deceased and the person who killed the deceased did not intend to give her room even for 1 minute to survive. Now, I've said Dr. Njenga said that the airwaves and the jugular veins were cut through and through. So I checked on the functionalities of these organs that were targeted. And this is what I found. The carotid arteries are major blood vessels that provide one's brain, supply blood to the brain. I established that a person has 2 of them on either side of the neck. I discovered that they're actually a cause of at least 1/3 of all strokes. And that a stroke occurs when something blocks blood flow to your brain and causes brain injury. Therefore, they are a very important part of one's circulatory system that sends oxygen-rich blood to organs and tissue in the head and in the neck, including the brain. And then checked on the veins that were targeted. And I discovered from my search and reading, they are major blood vessels that stretch from the upper head, from the head to the upper chest. There are 3 pairs, total of 6. And the reading, my further reading shows that when the arteries and the veins that were injured on the deceased body are severed or they're cut, then no blood is supplied, and the victim cannot even survive for a minute. It's my considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only, occasioned by a sharp object. It is my considered opinion the target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Does this connotes malice aforethought? I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation. It's no wonder then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. He's not a person who has no training in military, because the way it was done with such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses. And I'll start with evidence of Jennings. When he met the first accused person, they were on a VIP protection exercise, and it said that that is when the US president was in Kenya. And he says they then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company in Dubai. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Joyce Ray. It is the finding of this court that for one to engage in VIP training, they definitely must go through training. And that training would not be too far away from the training offered to a military officer. And if the first accused person went through this and he murdered the deceased, then he had the know-how. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence the first accused person told him, forget about the media, they won't help you. I don't know, you are here. I have a private company, let me do it for you. What does that statement speak to? A further issue I picked up, he says, look, the person whom the deceased allowed into her house was Dominic Becerra Harun. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Harun, the deceased would not have contradicted that because the deceased also introduced him as somebody who works at State House. So we all know that, hopefully, the court is making a right observation, I think I am, that people who work as undercovers will not quickly volunteer their true identity. And that could inform why, even when he said, I'm Harun, and the deceased knowing whom he has said he is, would quickly say, let Harun come in. And then in the house gives him his true identity to the other persons in the house as well. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. Cases that speak to circumstantial evidence. Some very critical areas, I think, will guide my findings. Ahmed, Mohammed, and another versus Republic 2019 speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given my own emphasis, on the following. It works by culminatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, it is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense, armed himself with a gun, carried a counsel, put it over his cloth, went to Ramuria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken culminatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case, the first accused, I'm still on the first accused person, committed that offense, it was not a case of homicide. Excusable homicide it was unlawful. And therefore I find the first accused person guilty as charged herein of the offense of murder, that on the night of 19th of September 2018, at an unknown time at Ramuria Gardens apartment, Kitale Lane off Dennis Prit, with others known before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One, saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause, or knowing it to be likely that he will thereby cause the person employed in public service, A, to do or omit to do something which the person employed in public service ought not to do, or omit, if true state of facts respecting which such information is given were known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officer at Langata Police Station, which turned out to be not true? I say no more. The Office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Nyawira Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We move to the next stage. The state you are supposed to go next.
You're the first one.
So I am expecting the records. If any.
You'll be asking for nothing. To present CRO report, which is the previous record for the first accused person who has been convicted. In the meantime, we'll also be asking for a pre-sentence report in relation to the first accused. And we'll also be praying that the first accused be remanded at Nairobi remand. As we await to get the previous condition and also the pre-sentence report. We'll also be praying for first copy of today's judgment.
Okay. May I know whether Professor Nandwa, you have anything to say? No. The victim's family, Musembi, sorry. Professor Nandwa, yes. Okay. Professor Nandwa, for the first accused person, you have something you want to tell the court?
Your Honor, first of all, we appreciate the effort that this honorable court invested in this conclusion. We do pray that we be given time also for us to prepare our mitigation. In favor of the first accused person. We also seek the indulgence of this honorable court that it maintains the bail terms that were granted to refer to the first accused person who can convict. He is not a flight risk. We are very concerned when the mitigation, when required by this court. We also pray that the exhibits that were and other items that were set which are of personal nature, given that the case has been concluded, and specifically on the forms. That's
My lady, in the last session we didn't take directions on dressing, so I pray that you excuse me on dressing.
That's okay.
Thank you. The second thing, and which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really wanted to know that. We appreciate as defense your attention to detail. My lady, for the second accused, we want to say, we wouldn't want to have taken it for granted. We are sorry for the first accused. We are grateful for the acquittal on the child that she was facing. And we pray, my
When this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court?
we can go.
I think it's administrative.
Yes, yes.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
And they do not intend to appeal.
I do not know where you get that from. I don't know. That I'll leave to you.
Yes, sir.
But of course, if they are not, after 14 days, you can seek for release.
Okay.
We need to give them the 14 days. Okay?
My lady, that's on behalf of the second accused. Thank you.
Okay, so a matter of this nature, you cannot afford to pronounce a sentence without, of course, a bail report, because it is that report that will take into account the views of the victim's family. And so we will start over this matter to another date when we'll be dealing with a sentence. It will also allow the prosecution an opportunity to seek for CRO, those are records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of. And it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant. We take a date for dealing with the sentence. Diary. Listen to my diary. Now, as I had indicated earlier, I'm starting my leave on Monday. I think Professor Nando, you are aware of that because there are other matters that you have before me. And so, just to guide you, I'd be away from the 12th of February to Court Assistant. You don't have a diary where I can just quickly pick 24 February. 11th of March. You'll be before me on 12th.
No, I'm in a court of appeal matter
On 11th. Okay, so you want us to give you the 12th of March?
Yes, 4th of March.
You have two other matters that are coming for judgment before on 8th of March?
On, yes.
8th of March.
8th of March. Can we make it on the same day?
Okay.
You are also coming here.
Am I coming here?
Yes, 8th of March.
Yeah, it's a Friday. I come here on a Friday. Okay, 8th of March. Yeah, okay. I thought we were dealing with those matters virtually, Prof. You want me to come here? Okay.
No.
That's okay. I can. Okay. May I have the first accused person stand up? You will appear before the court on 8th of March for sentencing. Unfortunately, after conviction, I'm unable to accede and or allow the prayer by your counsel for you to remain on bond. I'm cancelling your bond. You'll be held in custody until the 8th of March. Okay? So that is done. Assistant, put on the file. No, there's another file with prosecutor. So, as I adjourn court, may I take this opportunity once again to sincerely thank the first accused person. Please sit down. The counsels who've been involved in this matter. We've had dedication. I don't remember how many times this matter was ever adjourned because the counsels were not there. I do not remember how many times, probably the last time the matter was coming for judgment when the accused persons were not there. The state was always in attendance. And we've only been able to deliver this judgment because of that support that I got from the counsels on both sides. I want to thank you sincerely for that support you gave the court and, of course, the commitment. There are things that I will not want to speak to, but which, of course, we all know. But our general statement is always good to respect the court and just give the court its due respect. We don't sit in this court as in our personal capacity. I believe what I see behind here speaks to the authority of the court. And in most times, the court will not have an opportunity to respond to certain communications. The last bit of it would be me. And throughout this matter, I knew clearly what my purpose was to deliver judgment and not to get myself into response to social media or otherwise. And that has nothing to do with my decision. It has everything to do with a plea on my own behalf and on behalf of my colleagues and the entire judiciary. Let's support the judiciary. When a matter is still in court, it's just good to allow that matter to be dealt with. Any comments that would probably be adverse are not necessary. Please, Kenyans, support the courts. I'll leave it at that, okay? Otherwise, press, asanteni sana kwa kuja. When I called the parties to come before me on Wednesday and said, are you ready for this judgment? I knew the press had left knowing we are coming on 15th of March. Hope I didn't surprise you. But from the population I'm seeing here, I think information reached you in time. And as I'd said, please, for those who may not be able to come to court, make it online. And I had been assured that we'll have an online, but nothing lost. The most important people who needed to be present are in court. So asanteni sana kwa kuja. And finally, thank you for being patient with the court. My judgment is about 117 pages, and it may not take one day to write. Okay? If you want to know my workload, please visit Naivasha. You will understand. So for me to come up with this judgment, I don't want to praise myself, but sometimes it calls for quite a bit of work going into it. So I'll just say that thank you for being patient with the court, and I do appreciate the indulgence. Thank you. Yes, Professor, you want to say something?
Yes, my lady, I wish to reiterate our gratitude efforts that you have invested and the attention that you have given this matter. You have really always given it priority. We also respect your decision. We may not agree with you, but when we do not agree with you, the law provides for what to do.
Sure.
Therefore, rest assured that we respect you, we respect your decision, we shall live with it, and we shall act and do what the law provides for.
Yeah.
Appreciate your efforts, you have done your part, and God bless you for that. On behalf of the first accused person and the family, we really appreciate. I remember you allowed adjournment more than 2 because of you. We really appreciate that. And from on behalf of the pastor, the convict, and also the family, we appreciate and thank you very much. And God bless you.
Karibu. Yes.
I expected my senior to do this already. I just wanted to say, on behalf of all the accused persons already, we apologize for any excesses that may have emerged in the social media. And the same way you said you are patient, you thank the gallery for being patient. We want to thank you for your patience, my lady. And lastly, we saw you turn your back and look at the sheet. And we thought that was coming. Thank you very much, my lady. We want to say we are grateful and we apologize for the excesses.
Thank you.
Most grateful to the court for the diligent work that went into the judgment, the analysis. Thank you for bearing with us sometimes, bearing with counsel, with the media, even when we may have not pleased. So thank you so much.
I want to assure you this court is extremely at peace, and this court takes offense on nothing. Okay, so with that, kindly, may I request the court assistant, we now officially adjourn the court. Have a good afternoon.
File ndio ya maana. Hizi zingine watajichukulia. Nawekea tu hapa.
This week on Twende, we are at the home of champions. We will show you the amount of effort these people have to put in to deserve that name.
Hizi zinaweza kuwa zinaenda pesa ngapi hizi?
Ni around 25,000.
25,000 eh?
Yeah.
I'll also be hanging out with the legend himself. We get to Eldoret using a new route I have never used before.
Run! Hey!
To protect our family from germs that cause illness when it's cold, we use Dettol soap.
Dettol soap with germ defense gives you protection. When it's cold, germs are transferred in different ways, and Dettol soap's germ defense protects you from up to 100 illness-causing germs. Be Dettol sure.
Where were you the night that Virgilio was shot, Mom?
I had absolutely nothing to do with what happened to Virgilio. I could never hurt the one I love.
You were in love with Virgilio?
Can you spare some time to talk? In private, please. I have something important to say to you.
I saw Adrian downtown. I saw him talking to Amanda.
Do you think that woman is plotting against you?
I think it's time for me to use my secret weapon.
How did you learn to play that song?
It just suddenly came to me.
Harriet? You're Harriet?
Blue for the toilet and red for the bathroom. Harpic Bathroom and Toilet Cleaner cleans and kills 99.9% of germs and viruses.
I'm on a romantic call. Baby panda mti kama network ni blanda.
It's the month of love, and from the Teen Republic family, we want to share the love with you.
Would you be my Valentine?
In studio, we're going to be having the amazingly talented Vijana Baru Baru.
No way, no way, no way.
Na super producer mwenyewe Vince on the beat.
Mama praying for me.
Na kama kawaida hatukosangi a surprise artist, so be on the lookout.
I wanna know why you know.
Na mziki will be courtesy of our very own DJ Rickmo, the Afro King. Patane 10 o'clock.
I broke all the circles and chains, so thank you for praying for me.
Prudential is now